expired, the legal heirs, my lord, they filed an amendment petition. However, my lord, the amendment was not carried out by the department, my lord. So we
When it was directed, amendment?
my lord, that
I am appearing on behalf of the heirs of the executor who have now
yes.
been substituted as a
ये হয়েছিল?
this
When was it?
No, when was the order of amendment passed?
6th of March 2025, my lord.
Okay.
My lord,
This amendment,
mentioning slip.
Yes.
my
Give
lord,
the-
this amendment was allowed by the learned court, honorable court. Thereafter, necessary application and the order was filed in the department. But even till today,
Let it be carried out.
they have not carried out, and because I have thereafter filed another application in my learned client.
Anyway, that application is also disposed.
No, that is lying with the master, and the master has not taken any steps, my lord. Unless until the matter is listed tomorrow or day after as per my lord's convenience, no further step will be taken.
Anyway, I am granting you leave regarding that amendment extension of time.
My lord,
No, today you are seeking extension of time.
no, my lord, because as a matter of course, my duty as a
Okay, so let this matter appear.
Yes,
Yes,
my
my
lord, to be mentioned, my lord, tomorrow. Mentioning deeply obliged, my lord.
grateful.
The mayor permitted to mention matter is settled out of court, my lord. Finally, creative
This is outside the list.
matter is settled by the parties and out of court, my lord.
Okay, let
Agreement
it appear
to-
as to be mentioned.
to-
No, let us do one thing. Let this matter
Hmm.
appear tomorrow. You file the terms of settlement before the Lok Adalat, that is Saturday. Let it appear as tomorrow, as to be mentioned. To be mentioned tomorrow.
Lordship, may I be allowed to mention an application for amendment in a probate application?
Yes.
I'm grateful.
At number 16.
My lord, I am special officer in this matter.
Today is fixed for filing the report.
Yes, my lord, as per your lordship's direction, my lord, I visited the place on.
Are you ready with the report?
So, my lord, regarding the expenditure incurred by the survivors in the last 3 years.
So
only
report
the
is yet to be made ready.
Yes, my lord. Only the plaintiff has given the expenditure.
My client has made the
Yes.
statement, given the statement in
But the
correct.
defendant
So
has
I'm
not.
giving you 2 more weeks time.
Day
You come
after
ready.
tomorrow. Day after tomorrow, my lord. Time.
After tomorrow you can come ready.
Yes, my lord.
Okay, not today and tomorrow. Let it appear day after tomorrow.
Grateful, my lord.
Number 70.
Item 70. Yes, not today.
Number 18. Pushpati Datta.
Okay, not today.
Number 19.
Like this matter, my lord, I am for the sole beneficiary, my lord. The fact of the case is that, my lord, one Indira Prasanna Mondal died intestate without having any issue, and she was widow. And upon the death, my lord, the priest of the house made a will, manufactured a will, and got the probate. After in getting that information, we made an application for revocation of grant of probate. And kindly see the flag marking C, that is the appeal court order. Flag marking C, appeal court order,
Yes.
11th May 2011. 8 May 2011, flag C.
You have a copy of
Flag marking, no, my lord, that is on the record. Flag marking is there. Flag marking C. This is flag marking C, is appeal court order.
Let me see this.
Flag marking C, not A, B, C.
Again.
And kindly see the last page of this order. Executor to serve a copy upon the special citation should be served upon the heirs of the appellant, who is the heirs, only sole heirs.
Question is, at present, what is to be done today?
Actually, my lord, the last 20 years already passed, my lord, priest of the family, very unfortunately.
You have made an application for revocation of the grant of probate.
That was allowed. Kindly see the flag marking C. That is the appeal court orders. order passed by the Honorable Justice Oshim Banerjee and Minal Kanti Sina. 8 May 2013.
Okay, then last order was passed by coordinate bench on 5th March.
And kindly come to the last page of this order. There is a specific direction upon the executor to serve the special citation upon the appellant, so he can contest the matter. The passage of year, the 20 years already passed, my lord. The
Now the
probate file in the year 2022, now 2025.
terms of order dated 5th March 2025.
Not 5th March 2025. Kindly see the appeal court order, that is 8 May.
That is there, but thereafter the matter appeared before the coordinate bench. Let me see that order, 5th March 2025 order. I think the order was passed in your.
Yes, my lord. Justice Rao.
Now the question is, so the observation of the people of the coordinate bench is this. However, till date,
No citation has been issued upon us. And there is a specific direction upon the department to submit the report, and report has already been filed to the before this court.
Let me see the
And
order.
pursuant to that report, my lord, no citation has been passed upon the beneficiary, sole beneficiary. And already 2002 probate, my lord, already 23 years already passed. So now the very unfortunate case, my lord, the priest of the family who manufactured the will, he is enjoying the property. And who are the real beneficiary, they are depriving, legal heirs are depriving. So very sensitive issue, my lord. We have tried our level best to serve the notice to the lawyers, and they have refused to that. And that original letter is on the record. We have already filed before that Honorable Justice Krishna Rao, my lord, original letter. They have refused to accept that letter. So, my lord, they are not at all interested to proceed with this probate case.
No, we do not intend to interrupt your lordship, but there has been a resolution by the Bar Association as well
And
as
the
by
Bar Library Club, my lord, similarly.
from the-
In the view of the, my lord, sad demise of Mr. Jayanto Banerjee, was the president of the Bar Association and a secretary of the
Orders be passed in the absence of the learned advocates.
my lord,
No, my lord, also, my lord, we have requested our learned members not to participate in the proceedings. It's definitely
Also, my
not
lord,
in the bench.
no, lordship will kindly
Request is
consider.
made to the learned members of the bar.
Not to participate in the proceedings, as well as the request not to pass any orders in the
Absence of the party. My lord.
of both. the
Sorry to
sides.
trouble your lordship.
Yes. Anyway, that definitely that will be seen.
Lord.
That the absence of both the
Lord,
parties.
I'm
orders are
deeply
not
obliged
passed.
to your lordship. Deeply.
Yes, there are many matters fixed at 2 p.m. Anyway, I'll adjourn it at 2 p.m. Yes, because if now all the parties do not appear, matters cannot be taken up. Yes.
Much of it.
Then we are taking minus because we are under that minor will call now the PM matters.
No. How can 2 p.m. matters be called now?
Last 23 years, they are not interested. They have not shown any interest in this matter. They are not appearing in this court. And very unfortunate, my lord, a priest of the family enjoying the entire property and original legal heirs is depriving. They don't want to proceed. They never served any special citation upon the Monica Mondol, who is the legal heirs, only legal heirs. Kindly consider it and dismissed it. So,
Yes, department has sought some time for necessary compliance. Okay.
the compliance, my lord.
Yes, record an order. Learned advocate for the petitioner is present. Peruse the report of the registrar original site dated 2nd April 2025. It is observed that the only reason for not issuing the citation.
Is it acceptable, my lord, after 13 years?
Ms. Monica Mondol
Appeal
is
court
not
passed the order in the
communication,
2013, now 2025. Department asking for some time
non-communication
for
of the said
compliance.
order.
After
So,
12 years,
a
after
copy of
mentioning.
the order dated May. Okay. Copy of the order dated May 28, 2013, passed by the Honorable Division Bench, and the order dated 5th March 2025, passed by the learned coordinate bench, we complied with, and report we submitted with regard to the compliance. Honored report 24/10/2025. Let this matter appear on 27/10/2025.
And my lord, returnable on
27/10/2025.
27 October. When after vacation. I am grateful.
My lord, I'm appearing on behalf of the plaintiff, my lord, since my other side is not
Not
there.
today.
Not today, or my lord will fix up a. I shall indicate to
It will
them.
be done in the presence of the
Very well.
other sides.
Very well.
Not today.
My lord, I'm appearing for the petitioner in this matter. The indulgence I'm seeking is only clarificatory in nature. On 14th of August 2025, your lordship had allowed my application for amending my name. Your lordship remembers that was for the amendment of the name of the petitioner company. However, my lord, there are 3 defects that are there in the order dated 14th of August 2025. First of all, in our notice of motion, in one of the prayers, the
Let
case
it appear
number.
tomorrow in the
Well,
presence
this is
of the.
only clarificatory in nature. No hardship will be caused to the other side. If your lordship
Let me
will.
see the order.
Yes. Your lordship kindly sees the second page of the order. The case number has, in notice of motion, the case number has come as wrong. And in the order, the date of the notice of motion has come wrong. Instead of 20th of March, it should be 28th of March, my lord. Accordingly, since 2 weeks period has elapsed, my lord, now if I go to file the amendment, I would require some additional period, my lord. Let that period also be extended.
The order was passed when? 14th of August.
My lord, in the prayer A of our notice of motion, the case number is CS 24 of 2016, my lord. However, it should be 2013, my lord.
No, in the order sheet it is appearing 2013. Order sheet it is
My lord,
CS
CS 24 of
2013 as per the order sheet.
my lord, it has to be done in accordance with the notice of motion. And second of all, the date of the notice of motion is perhaps recorded wrong, my lord. Instead
Date
of
of the
20th of,
notice of motion is 20th day of March.
my lord, it should be 28th, 28.
28.
Yes, my lord. And let that period of 2 weeks also, my lord, be enhanced because
So the date of the notice of motion be changed from 28th March
to
it should be
28th of
28th.
March, my lord. And since the prayer A in our notice of motion, the case number is recorded erroneously, may that also be corrected, my lord.
So in the master summons, what is the case number recorded?
Prayer in our prayer A, my lord, it's recorded as CS 24 of 2016. However, it
So
has to be,
that should be corrected. So
my lord.
So why didn't you mention when the matter was called on, when the order was passed?
My lord, it perhaps.
So now you see, this is not the order of the mistake of the order of the court. It is mistake recorded in your master summons. So it's better you serve notice. Let other side come tomorrow.
Very well, my lord.
Not today, just. Other side is not. Not today. Not.
My lord, I'm appearing on behalf of the applicant, me and Mr. Dasgupta. My lord, this is a substitution application, my lord.
Now, the applicant had taken out an application being 269 of 2024, seeking to be added as a party in the suit. During the pendency of the same lordship, the petitioner passed up
24.
item 24. The present application for substitution is GA 284 of 2025.
Yes.
Now, he's asking for, the heirs are asking to be substituted in place of the original applicant, my lord, in the application for addition of parties. If I may just indicate, my lord, may be pleased to come to page number 28. That is the death certificate, lordship.
Yes, 28 page
Page 28, lordship.
of this GA 284.
284.
Yes.
That is the death certificate, my lord.
No. This is not the death certificate, page 28. This is Annexure B.
Annexure B. That is the death certificate, my lord.
B, my lord.
He passed away on 27 January 2025, lordship, leaving behind 3 heirs.
That is the applicant. Who died?
Yes, my lord. Now, the following page, page number 29, my lord, will find the legal heir certificate.
Not paginated. This 29, what are you telling? It's not paginated.
Not paginated, my lord.
You see?
Will it be my lord's pleasure, my lord? We will paginate in the course of, then it can come up anytime, sir, because
Not
this is
today.
not right. This is
Just
not at all.
today.
In this matter, I have been appointed receiver. Petitioner want to open a savings bank account in the at Punjab National Bank High Court branch in the name of Sri Sri Lokhi Janardhan Thakur, Sri Sri Bhoirasov Shiv Thakur, and Sri Sri Koilanath Shiv Thakur, operated by present receiver and one of the joint administrator. Nothing more, my lord.
Question is 11/6/2025. That is the order.
Yes, my yes. Petitioner cannot operate the account, my lord, kindly.
Okay, 1 year, my lord, account
already held up here.
Held up.
I have been also suffering, my lord. I could not. My remuneration and staff there to salary.
Salary is what?
Nothing more. I have no objection. This correction.
Well, it is a perpetual minor.
So it should be operated by the receiver and
one of the joint administrators.
or both the joint administrators, or anywhere any one of the joint administrators, either or.
Nothing more, my lord. Modified.
Modified.
Yes, record an order. The applicant is one of the trustees.
One of the trustees.
Applicant, one of the trustees, appearing in person is present. Mr. Mukherjee, learned receiver appointed in this matter, is also present. The applicant has prayed for an order that permission be granted to open a savings bank account in the name of 3 deities, namely Sri Sri Lokhi Janardhan Thakur, Sri Sri Bhoirabeshwar Shiv Thakur, and Sri Sri Koilanath Shiv Thakur, on the basis of original PAN card in the name of Sri Lokhi Janardhan Thakur. It is also prayed that the savings bank should be operated only by the present learned receiver Shamsundar, only by present learned receiver Mr. Shamsundar Mukherjee, and also by any one of the 2 joint administrators. In the facts and circumstances, the petition stands allowed. The applicant trustee is permitted to open a savings bank account in the name of three deities, namely Sri Sri Lokhi Jonathan Thakur, Sri Sri Bhairaveshwar Shiv Thakur, and Sri Sri Kailasnath Shiv Thakur, on the basis of original PAN card in the name of Sri Lokhi Jonathan Thakur. The said savings bank account should be operated by the learned receiver, Mr. Shamsundar Mukherjee, and any one of the two joint administrators. The application stands disposed.
Grateful. Yeah. CS case নাম্বারটা দেয়া আছে তাহলে তো হবে
Not today. Not today. Not today. Not today. Not today.
The 31 will pay for password, my lord.
Yes. Yes.
My lord, praying for a password, my lord. She is the education record is in a
You are appearing for
31.
31.
30.
30, I just made it not today.
My lord, affidavit of documents has not been completed, my lord. Kindly make it 1 week after application.
I'm for the defendant, my lord. It's just been, they have been taking time.
Item 30.
30.
Yes, item 30, record and order. On the prayer of learned advocates, the matter stands adjourned till
1 week after. 1 week after.
29/10/2025.
Deeply obliged, my lord.
Item 31 paying for password, my lord.
Okay, let it be not today. Other side is
Yes,
not
my
there.
lord.
Not today. Not today. Not today.
35.
Not today. Not today.
37.
My lord, I appear for the
Yes,
plea.
37.
Yes, my lord.
Yes.
My lord, in another proceeding, my lord, involving the same party.
No, GA14, whose application?
That's the plaintiff's application, your lordship. I
You are
appear for defendant number. I appear for the defendant number 2, lordship.
So all
these
parties are before the court today.
Lordship, this matter has
Well,
already
this
been
is-
adjourned till 24th October 2025. This is
Yes,
the
my
order,
lord,
your
this is
lordship.
the-
So this is appearing wrongly, your lordship.
Only item 37.
Yes, my lord.
Lordship, all
37 to 41.
Item 37 to 42.
Yes, your lordship.
41.
Okay, item
May I
37.
just say this, my lord. I am the receiver appointed in this
On the
matter.
same suit.
I'm seeking from my lord.
No suit, no suit.
For the interview, 42, I think you're there on 42.
2004 is suit.
42 there.
No, all the matters are due to appear when?
24th of October.
20?
24th of October, lordship.
Yes.
The interim order which they had prayed for had already
My
been
lord, we
extended.
extended till 24th of September, my lord, if it may appear at the same time, and the interim order may be
Record and
extended
order.
till then.
Learned advocates for the parties are present. The matter is due to appear on 27/10.
Lordship, 24th.
Okay, 24/10/2025. Let the matter appear on the said date. The interim order granted earlier stands extended for a period of 1 week after vacation or till further.
Lordship,
Yes.
that
I'm just making it 1 week after vacation.
Very well, my
Just
lord.
few days after.
Grateful.
1 week after vacation or till further orders, whichever is earlier.
My lord,
Or
item number
37 to 42.
41, my lord. 42 is another suit, my lord, involving the same parties.
Okay, 37 to
My lord, if it may appear at the same time.
37 to 41, same order. 37 to 41, same order.
yes, your lordship.
Yes, item 42, let this matter appear on.
Along with
I was the receiver appointed. My lord had directed the parties to finish square off the remuneration prior to my discharge. I am seeking my discharge, my lord. No, possibly, my lord, there is no job that remains for me to be done in the suit.
Anyway, some regarding
if
some
it may-
accounts, probably.
No, my lord. May I say this? My lord? I was appointed to inspect the property, not with respect to collect any monies. prior to the inspection being done, parties arrived at a situation.
Anyway, you are already discharged, order is
No,
passed.
no.
So any remuneration due?
Yes, my lord.
So let the remuneration be paid.
There were
Let-
directions on that tune also.
No, I am keeping it on the next date.
my lord.
Let
In the meantime, my lord,
some remuneration be paid.
I shall.
How much you received
My lord,
last?
My lord, 17.
there was a division of remuneration, all parties but the plaintiff has paid.
Anyway, whatever it is, how
Yes.
much did you, when was the last remuneration paid?
Sometime, my lord, last month.
Last month?
Yes.
Yes, record an order.
Yeah,
Let this
no.
matter appear on 27/10/2025. The learned receiver who is seeking discharge is requested to be present on the said date. Let the remuneration of the learned receiver which is not yet paid be paid. Not today.
As per order,
Not today. Not today. Not today. Not today.
Your Lordship, in 48 and
48 and
49.
49, you are
Your Lordship-
appearing.
Yes, Your Lordship, I'm appearing. Your Lordship had fixed this matter at 3 p.m. today. Your Lordship, since because of the resolution, I'm only humbly beseeching Your
48,
Lordship.
49, not today.
Lordship, kindly fix it any other day before the vacation because it was already fixed today at 3 p.m.
So I'm
But it
making
was not appearing as 3 p.m. fixed, Your Lordship, in Your Lordship's list. If Your Lordship kindly takes up Your Lordship's last
This
order.
matter was fixed. What is this? A hearing of this application?
Yes,
G18.
yes, Your Lordship.
G9 is for what?
Your Lordship, challenging the order of the learned special referee fixing the occupational charges.
Okay. Let this matter appear on. Shall I keep it after vacation or before?
So before vacation, kindly fixes it one day. The
Learned,
arguments had been commenced.
Learned advocate for the petitioner is present. Let this matter
I am for the
appear.
respondent in the application.
Petitioner in GA 9 of 2024 is present. On the prayer of learned advocate, let this matter appear on 17/9/2025 at 2 p.m.
Grateful, Lordship. The advocate for the respondent. I'm for the respondent in that application.
Oh, GA9 is your application?
No, Your Lordship, I'm the respondent in that application. The plaintiff is the other side has challenged the report.
So it's better that I make it just not today and tomorrow.
It was already fixed at 3 p.m. today. Lordship, if Your Lordship kindly sees the order because Your Lordship has heard it in part.
17/9/2025 at 3 p.m.
At 3 p.m.?
No, 2 p.m. 2 p.m. Because 3 p.m. appellate said matters are being taken up.
Very well, Lordship. The only correction need to be advocate for the respondent.
For the
Respondent.
opposite party in GA 9 of 2024 is present.
Grateful, Lordship. Grateful.
हो जाएगा petition जाएगा respondent बोलते हैं एक party
My lords, kind leave to mention item number 3, which is specially fixed at 2 o'clock for hearing the third matter. Mr. Sharnendu Ghosh is not here. So, my lord, I don't think your lordship would take it up. May I just have, my lord, the permission to, my lord, file the note?
GS7.
Yes, my lord. May I
Item
just?
number 3.
Yes, my lord.
GS7.
May I just file the notes of argument?
Okay, the other side has filed their notes about
Other side is already filed. My lord, this is that matter, my lord, regarding
Shall I
transfer.
make it not today or shall I conclude the hearing?
No, my lord, kindly make it not today. I'll just file the note if your lordship is pleased to see it. And then, my lord, otherwise, Mr. Sharnendu
record and
Ghosh
order.
will be upset with me.
Yes, Mr. Chaudhary, learned advocate for the defendant, is present and files the notes of arguments. Let this matter appear on 15/9/2025 at 2 p.m.
2 p.m. Grateful, my lord. My lord, I'll just hand up the note.
Yes.
And
Let
one
the-
judgment I'm relying upon.
Whatever it is.
Yes.
With your lordship's permission, I'm mentioning a matter of the appellate side, your lordship.
Yes, appellate side?
Indeed, your lordship.
Yes.
Lordship, item number 120, your lordship. We are praying for the quashing of the proceedings.
Just a minute. Okay, let the original side be over.
Ma-
Yes, any other original side matter?
Lord, item
Yes,
number
fine.
1 at 2 p.m. Lord, today.
Yes.
Lord, it is for fixed for arguments. Lord, my application for grant of probate, which has been now converted into a testamentary suit. Lord, the caveators, Lord, caveat 6 has Lord already started his arguments. Lord, I believe Lord, he's not here today. So, Lord, if your lordship Lord, kindly fixes it, Lord, tomorrow, day after, any day.
It will be not today, just simplicity and not today.
Lord, in that event, Lord, then the fixed timing will be not be there. So, if your lordship, because it's your lordship has heard it.
Item number 1, let it appear as to be mentioned on 10/9/2025. In the presence of both the sides, I shall fix a date. Let it appear on 10/9.
Tomorrow, your lordship can not keep it because I
giving
believe
it as to be mentioned on 10/9, day after tomorrow.
very well, my lord.
In the presence of both sides, I shall fix a date.
Very well, very well.
May I have your lordships kindly?
What are the na-
Item number 2. This was for evidence
Witness
cross-examination
action,
of my witness.
I was crossing. Oh, mention.
Mention.
Yes, RKG mentioning.
Yes, my lord. Yes, my lord. My lord, kindly consider our specially assigned matter.
Which
with-
case? Is
with
it
the-
appearing in the list?
Not in the list, but my lord, it is not coming in the list, my
Okay,
lord.
give the slip, it will appear.
Actually, my lord, I want to say that except me, no advocates could give any.
It appear in the list, I shall see to that.
Yes, my lord.
Well, the witness was in the box. My learned friend's witness. I was cross-examining the lady in a probate proceeding, my lord. But today I believe that the witness has not come.
You are
Because
for?
of the resolution. My for the defendant number 1.
So let a date be fixed.
How witness was in the box?
My witness.
Yes, so let a date be fixed.
Let a date
You are
be
for the
fixed.
plaintiff.
But today was the date for witness action. So I was
Witness-
ready
no,
for
no,
the
witness is present.
no.
Not
So a
present.
date has to be fixed.
I know that has to be fixed. Maybe after the vacation, not on this part of the vacation anymore.
Okay, prior to vacation, not possible. Yes, record and order.
It's a request to the court, whatever. I am not forcing.
Learned advocates for the parties are present.
Whatever.
On the prayer of learned advocates, matter be fixed on 28/10.
28/10. We are reopening on
After today, 24th.
Oh, 24th.
Tuesday.
28/10/2025 at 3 p.m.
27, 28, bolting?
28/10/2025 at 3 p.m.
Second day of reopening.
Third day.
Yes. Oh, 30th will be possible for my lord. 30th, the next 30.
Holiday probably. I see it's a red letter day.
Oh, sorry, 30th.
So let it remain on 28 because it is not the reopening date.
Oh, 31st, my lord, it was a Friday. Oh, it can be a reopening also because today.
Are you agreeable on 24?
Don't keep it on the first.
27th. We come back on 27th.
আচ্ছা ওটাকে 28 এর জায়গায় 27 করে দিই ঠিক আছে
27th is
27 at 3 p.m.
ठीक है तो किच्चू হবে না কিচ্ছু कैफे 3 p.m. 3 p.m. on 27th अब लाइज में अरे छोट तुझे मैंने हाईकोर्ट করবেন
কি বলছো তুমি
Four millet, I am ready, millet. I am from defendant number 1 to 4. Millet, I used to argue.
Appearing on behalf of respondent number 5 to 9.
Yes. So,
My
millet.
lord, I am appearing on behalf of the plaintiffs, my lord. Mr. Mukherjee has already completed their arguments on in GA 16, my lord.
These have completed, the applicants are completed. It's my lord's orders for me to start. Millet, I can start today, millet.
All parties are before
Yes,
the court.
millet, all the contesting parties are here.
Very well.
Millet, the issue pertains to millet a partition suit that my lord has millet hearing. Now, millet, there are millet in 5 groups. Millet Anil Patodia group, Sunil Patodia group, millet Pawan Patodia group, and Shushil and Shudhir one group.
Yes.
Now, millet, this application has been filed millet by the Pawan Patodia group. Now, my lord will see from the records that millet.
What are the need? Your application is GA?
Millet 16, millet my application.
So now you see.
GA 16.
You are contesting
Yes,
the
yes.
application filed by that. Regarding GA 16 was heard.
I am replying on GA 16.
Yes, GA 16 your opposition. Yes, the application of the defendant
Yes.
number 5 is being
5.
kept now.
It's one group.
Yes.
Now, my lord will find.
Let me consider your opposition.
Yes. Millet, my opposition is 2-3-fold, millet. First is, millet, identical application was filed being GA number 14 of 2022. Identical application was filed. Millet, during the pendency of the said GA 14, millet, this GA 16 was filed. With the similar prayers, similar reliefs. Millet, I am carrying, millet, there was an order passed by Justice Rao to keep millet GA 14 on record, millet, before lordship, but I am carrying GA 14, millet.
No, that 14 was filed by this defendant number 5.
Same. He has filed, millet, total, millet, 4 applications. GA 14, GA 15, GA 16, GA 17.
So GA 16 he has filed for interim relief.
Interim relief, identical reliefs he has prayed for in GA 14 and GA 15. GA 14 টা brief টা আছে? না মিলাদ no brief টা. Apart from this, milad, my endeavor will be to show before your lordship that, milad, the reliefs which has been claimed herein is wholly barred under section 430 of the Companies Act 2013. Number 2. Number 3, I'll just try to canvass the point wise. Number 3, this same plaintiff way back in 2014 had filed a separate suit. Not this suit. Had filed a separate
this
suit.
Defendant number 5 filed a
Separate suit being a plaintiff there. That is kindly text record. I'll give the copy. Civil suit number 411 of 2014 before this honorable court. Where, Milad, my clients were the parties. Defendant numbers 1 to 4, 1 and 2, along with Milad, defend number 46 and 47 here. Ganesh Nirman and Unique Nirman. Before Lordship's court, this plaint. Kindly see defendant number. Yes, 47 and 48. Ganesh and Unique. Two family companies. Two companies. Now, Milad, in that suit, they were unsuccessful to obtain any interim relief.
So the suit is pending.
Application GA1, that point in time, the GA1 scenario was not there. It was the longish number. GA3782. On 28th of January 2016 has been dismissed for default. This is the copy of the order of that suit. I will also give the copy of the no restoration had been made.
No. What was the subject matter?
Yes, I am handing over the plaint copy. At our extra copy.
And what is so far this plaint suit is concerned, there is no such plea that this.
Yes.
So far,
no, this plaint has been filed by another brother. So far as this application is concerned, there is no such plea that he has filed a prior suit.
Is it between the self-same parties?
Part of the parties, not the entirety.
Okay.
Because today he is also seeking orders against Ganesh and Unique and my clients.
The question is, you see, what are the relief? Okay.
Yes, I am coming to the relief.
The question is, res judicata and the stay has to be based on the reliefs claimed and the subject matter.
Your plan. Order a copy. May I hand over a copy of the plaint filed in civil suit number 411 filed by the applicant here?
Because you see, this is a suit for administration and partition.
That was also framing of scheme, administration. Kindly comes to page 31 of the plaint, that plaint, 411. Kindly see the cost title.
Yes. So page 31. That is the relief.
That is the relief. Prior to kindly see the cost title.
Okay.
Pawan Patodia, Sushil Kumar Patodia, Sudhir Kumar Patodia jointly filed a suit. That is Mr. Sen's client along with the applicant. Against 47, defendant number 48 and defendant number 1 and 2 in this suit.
So it was
they were defendant number 1 to 4.
Team of management.
Yes. And the injunctive prayers are also there. Kindly comes to page 31.
Yes. Yes, 31.
Similar nature of prayers were sought for against those two companies, including my clients.
No individual was a party in that suit.
My client was individual. Kindly similar the cost title, the second page, defendant number 2 and 3, defendant 3 and 4. Kindly see, page kindly comes to page 2. Sunil and Shakuntala, they are defendant number 3 and 4 in that suit, and this suit defendant number 1 and 2. Now, this they were unsuccessful to obtain nature, in a similar kind of order. They are now seeking before your lordship against the self-same companies. And ultimately that GA got dismissed, no recalling filed. If no recalling, no restoration filed, my lord knows fresh proceeding cannot be drawn.
Question is, you see, whether this suit is maintainable against these two persons, that is also another question.
That these two companies had filed 2 GS before your lordship for striking off on these causes of action.
Okay, these two companies filed a petition for striking
off their name. Those are pending before lordship, also appearing today. No step taken, abandon the suit. Suit is still pending. Suit is still pending.
Thereafter, it was restored.
No, suit is pending. GA was dismissed for default, the injunctive.
GA was.
Yes, order 39 rule 1 and 2 GA. GA was never restored, no restoration application filed. Unsuccessful in getting any order.
So this prayer B is a subject matter in this prayer, in this application. Prayer B.
They have prayed for similar kindly match.
Prayer B in that suit.
Yes, they have also sought for declaration of the subsequent board meetings. Subsequent board meeting, naturally, subsequent board
means these defendants.
This defendant, those are applicants here. They are plaintiff there.
But in the instant suit, how many defendants they are seeking to proceed?
That includes 47 and 48.
77 defendants.
There are 77 defendants. They have sought relief against 47 and 48, including my clients also, who are 1 to 4 here. 1 and 2, 3 and 4 were not a party to 411. So at least against 2 companies, this application is barred. Because if you are not able to obtain any order of a prior board meeting, you cannot have on the subsequent one.
Yes, that means against these 2 particular 47 and
48.
You are representing only this 2.
No, I am representing 1 to 4, 47, 48, 56, 55, 56. 56, 55, 56.
So 47, you are against
And
47 and
52.
48, the application is barred according to you.
Yes.
43.
43, I am also appealing for 43, 52, 55, 56. Okay. I am appealing for 1 to 4, 43, 47, 58, 52, 56. So against 47 and 48, these reliefs are barred. I will go one by one. And circumstance and it's also barred against defend number 1 and 2. Now, this application, apropos for defend number 1, 2, 47 and 48 is barred under order 9 rule 13 of the code. A fresh action is not maintainable if a party had appeared and the plaintiff had not appeared and the suit is dismissed.
The application is dismissed.
Application is dismissed, yes. Default. A fresh proceeding is not maintainable. This is one of the defense.
Yes.
Now third, and which is most importantly that who are the applicants? The applicants are at best shareholders. And shareholders, this is a settled law that shareholders cannot have any right whatsoever over the assets, whether fixed, movable or immovable, of the assets of the company. Not to receive, it's been settled law from 1956. If today any injunction is being passed, that will be passed at the instance or behest of a shareholder against against companies who are separate juristic entity. Now fourth point is that they say that the suit consists of family properties. That has to be proved. that the companies can be intermingled and can be brought into this hodgepodge.
That is the subject matter of the suit.
That has to be proved prior to, before getting into any, again, individuals, two brothers fighting for a household property, no difficulty.
So regarding this 1 and 2, they are also the shareholders.
Shareholders,
Member of the family.
member of the family. But what we get in usually in other partition suit, 2-3 household properties, 2 brothers fighting, 3 brothers fighting, can easily pass. The status quo to be maintained till the suit is not.
No,
But
there are several properties.
Several properties of
The name of the company also.
companies.
Yes.
Of companies, and these are has to the companies are separate juristic entity. And no, this is this has a checkered history. The brothers had tried mediation. Now in the mediation, the companies had objected that we should not be sent to mediation. Ultimately the mediation failed. Late Mr. Kapoor was SK Kapoor was the mediator appointed by Justice Somen Sen. He has tried his level best. But he also found that 5 individual brothers very well it can be reached. But when there comes the juristic entities, there are also shareholders who are not part of the family.
Yes.
100% not being held by the family.
Shareholders not part of the
family. So they had objected to that why should we be sent to mediation? Because we are juristic entities. Ultimately, the mediation has failed. Now, more glaring, I'll produce the plaint. On the same cause of action, in Alipur court, a suit is still pending. Where this applicant is also a defendant filed by this plaintiff. I am not only against this this applicant. I am saying that this suit is of 2013. 2012 suit is pending before Alipur court.
Whether at present any plea is taken that the suit cannot be proceeded with as self-same cause of action is pending.
Yes, I've taken the plea in my opposition.
No, that let the further proceedings of the suit be stayed.
No, we have
for simplicity, you want your name to be deleted.
My names to be deleted with regard to the juristic entity. Anyway, I can't get my name deleted with regard to the individual 1 to 4. The deletion has been filed by the juristic entities.
Okay, to get the name deleted.
Yes.
Only 2 juristic entities.
No. 20 item number GA 20 18
47
19,
and 48.
GA 18 19 20 21 22. 5 applications filed by
5 companies.
Five companies.
Yes.
Now, up 2012 comprehensive suit pending before the learned Alipur court. Yes, sir. Now, that has not been disclosed in this application. Where this applicant is also a party.
Who has filed that suit?
This plaintiff, Anil Patodia.
Okay, Anil Patodia
has filed. I am also a party. This applicant also a party.
Did the plaintiff disclose that the suit is pending in his opposition?
I am not favored with his opposition. As a co-defendant, so I am not favored. Copy there.
For some time.
Yes.
I will give my reply thereafter.
You are for?
I am for defendant numbers 12 to 17.
12 to 17. So this is the application of
5.
Defendant number 5.
I will have to make my submissions on the application.
Okay, independently.
I was praying a lot after my learned. Kindly keep a date for when I will answer.
But anyway, I'll not finish today.
I will only not be available up to the 18th. Kindly accommodate me.
The date টা fix করিয়ে নাও না, সামনে fix করো।
It can be on 23rd or
But only
22nd.
few days will be left for vacation. So
Well,
whether at that point of time these hearing matters can be taken up or not, that is also a question.
But you should not let it appear in the list.
Anyway, I shall fix it on 23rd.
time করো না, 23rd কখন?
23rd, 2 p.m.
Whether it will be possible or not, I cannot say. Just before vacation.
And if time is not a problem, আমরা চলো সারাদিন আটকে যাবে।
But sometimes
Please, I should difficult always convenient for all of us.
See, now this court is taking appellate side matters from 3 p.m. Okay, that is why it is difficult to fix times. So very difficult. Yes, it will appear on 23rd.
23rd.
it's very tight down. Yes, that is from.
Now, my lad, these are the 5 points which, my lad, I'll try to canvass before your lordship. Now, my lad, going back, my lad, to the kindly takes my lad GA 16.
Yes.
Now, my lad, kindly takes page 31, para 33.
Yes.
The petitioner, being surprised of such act of defendant number 15, became suspicious and made searches. Pursuant to the sale of the assets, defendant number 35 and defendant 16, no meeting has been held for the discussion on the distribution of the remaining proceeds with stakeholders. The same balance sheets also showed that the equity shares of the defendants 5 group, being defendant number 6, 8 and wife of defendant number 9, had been misappropriated and shown to have been transferred to plaintiff number 1 and defendant number 12. The balance sheets further showed that a dividend of almost 1 crore was paid to the alleged shareholders of the defendant number 35, including a sizable payout of about rupees 35 lakhs to defendant number 16, which was over and above her shareholding. These dividends were paid in the same month as the receipts of the proceeds of sale. This was never put up or approved by the shareholders in any general resolution of the company. Kindly mark this word, millet, company, as is required for approval of the dividends. Plaintiff number 1 had converted defendant number 25 from a company limited by shares to a private limited company in June 2020. Plaintiff number 1 had also shown defendant number 5 and his HUF has transferred his equity shares off and in the defendant number 25 to him on January 19, whereas the purported gift and or sale took place only on March 2019. Now, millet G, the defendant number 1, 12, defendant number 15 have signed and filed various balance sheets of defendant number 56 for period of 2009 to 19. The same was never informed to the defendant number 5, who was also a director of defendant number 56. The defendant number 5 is still a direct shareholder of defendant number 56 as per the annual returns of the company for March 2020. The said defendants never made any attempts to file these records all these years, resulting in mismanagement and disqualification of various directors. So, they even use the word nomenclature mismanagement. I'll try to canvass before your lordship that they not only use these are all the causes of action where we can approach the NCLT. And these are all the grievances which the NCLT is empowered with, and usually we file application for 241 and 242 for mismanagement and oppression by a shareholder against the majority shareholder by the minority one, or the vice versa is very rare, by the majority against the minor. Now, my lord, may I proceed? The defendant number 12 and 15 in collusion and connivance with defendant number 1 appointed defendant number 2, defendant number 3, defendant number 12 and defendant number 17 as director of defendant number 56. However, the same was suppressed on defendant number 5 and his group. The defendant number 1 and 15 thereafter showed themselves as voluntarily retiring from the board of the company. Furthermore, defendant number 3 filed cessation of defendant number 5 and plaintiff number 1 by DIR 12 dated October 13, 2021. Oddly enough, defendant number 12, who held controlling vote share in defendant number 56 through defendant number 49, continued on the board of the defendant number 56. So, Milad, these are the reliefs of Milad appointment, removal.
These are the grounds.
Milad appointment, removal, and Milad not suppressing. Milad, these are the appropriate cases which Milad NCLT is a specialized authority empowered with under the Companies Act 2013. And Milad, I'll try to canvass before your lordship, Milad, this kind of cases are barred to be Milad adjudicated before any civil court. There is a specific Milad section 9 of CPC allows Milad the civil court to accept any suit, save and except specifically barred.
No, you see, so far the suit is concerned, suit is for a specific relief. Okay.
Right. I am on the application
now
also.
The question is whether during the pendency of the suit, this application can
yes,
be made.
I'll come to the because
how far the suit property is to be protected.
Very well.
That the court has to see.
See. Now, Milad, my lord, seen the grounds.
Yes.
My lord, will also have to see Milad the reliefs. Whether these reliefs can be granted by NCLT. Whether these reliefs are Milad barred under section 430 of the Companies Act. And Milad, there are Milad catena of judgments of Milad Honorable Supreme Court Milad as on date that Milad any Milad issue which is being barred under section 430 cannot be granted by a civil court. Now, Milad, may I proceed? Now, Milad 34. The petitioner states that after getting such information, made various searches at the Register of Assurances and the applicants receive a copy of sale deed dated March 2, 2020, wherein the defendant number 6
of the petition.
Page 33, para 34.
Yes.
Wherein the defendant number 16 and 17 being directors of defendant 35 company sold and or transferred the residential flat at 6A Ironside Road belonging to the defendant number 35 company in favor of one Ambika Bagaria and Jayashree Bagaria for a total consideration of rupees such and such. The petitioner state that after such transfer of equity shares, now Milad the issue of equity shares of the applicants by defendant number 16 and 17 as shown in the balance sheet, the defendant 35 company is bad, illegal, null and void and are liable to be set aside due to the reasons. No transfer deed has been executed. No consideration received with regard to the purported share transfer. The purported transfer is in violation of Milad. Kindly see articles of association also in a provision of Companies Act. They themselves admit. Now, Milad 4. The transfer is per se oppressive. So, Milad, their relief lies under 241 and 242 of the Companies Act for mismanagement and operation. Has prejudicially affected the rights of the applicants in the company. The transfer of equity share is against the interest of the shareholders being the plaintiffs herein. The said purported transfers are against the equity. The dividend shown to have been declared is out of the proceeds which has not been approved in AGM of the company. So, Milad, my lord, will have to now delve into the whether the AGM was proper or not. Now, one of the reasons of share manipulation has been to pocket an illegal dividend by beneficiaries and the dividend is declared out of capital receipts. Now, Milad, kindly takes Milad paragraph 36. Well, I'll just Milad go one by one Milad in a nutshell Milad to show Milad these are all the reliefs, all the grounds are Milad barred under section 430. The petitioner states that further the plaintiff number 1 and 2 in collusion and connivance with defendant number 12, 13, 15, 16 and 17 have perpetually shown equity shares held by defendant number 6, 8 and Radhika Patudia being family members of the defendant number 5 group of and in defendant number 35 transferred. So, Milad transferring of shares of and in the company. The aforesaid acts are illegal, bad, malafide and such and such. Now, Milad kindly comes to Milad paragraph 38, page 36. The petitioner states the defendant number 5 family group at all material time held 30,000 equity shares, often in defendant number 35. Company. However, defendant numbers 16 and 17 have purportedly and in collusion and connivance with the plaintiff number 1 group, defendant number 12 group and defendant number 15 group have struck off the name of defendant number 5 group as shareholder of an in defendant number 35 company. Millard, a copy of annual return of defendant number 35 filed on March 2020 are annexed. So, Millard, deletion of names from the register of companies, whether proper or improper. It's clearly barred, Millard, under section 430.
You have disputed this fact.
Yes, in my opposition, I have taken all the demeanor points.
No. Question is regarding this 38. This paragraph have you disputed?
Millard, I don't appear for 35.
No. Paragraph 35.
It's concerning to
38.
Yes, it's concerning to paragraph Millard, defendant number 35.
Okay, so the question is, defendant number 35 has knowledge about all these things, about the allegations made.
Millard, defendant number 30, Millard, I am on the point that Millard cannot cut it out and segregate.
Question is, you have filed your opposition.
Yes.
What is your stand with regard to?
Millard, my stand is very clear.
So let us see that paragraph number 38.
No, my stand is very clear. My stand is, Millard, not only 38. I have dealt with, Millard, the prior paragraphs also. My stand is that this reliefs. Well, I'll take Millard to the relief first, then to the opposition.
That is a question of law, definitely.
Yes. Then Millard kindly
so
takes.
Let us see your stand with regard to the allegations made.
Yes.
Paragraph 38.
Very well.
Here din to opposition stand.
1 to 4 er opposition. 47. There is a joint opposition.
না
না এটা অনিল কুমার
আমাদের
পাতোদিয়া
backsheet হবে এটা
এই দেখুন এরকম 2 48 49 56 সবার একসাথে এই যে এরকম
ডেটটা নিয়ে অ্যাফার্মেশনের ডেটটা একটু বল
6 ফেব্রুয়ারি 2023 এর দেখুন
অপোজিশন এখানে আছে তো কিছু
এটারই করা এটা 3rd জানুয়ারি এটা না এটা আমরা ডিজাইন করে দিয়েছিলাম
এটা তো অরিন্দম পাল
এটা অরিন্দম
আরএল মিত্র হ্যাঁ kindly Millard, I'll directly take my lord to page 30 para 21 which deals with this paragraph.
Yes.
With reference to allegations made in paragraph 33, 34, 35, 36, 37 till 40, Millard, I repeat and reiterate the allegations such and such, which are extant. The allegations have been made in the present application with mischievous intent and to mislead the Honorable Court. The petitioners deliberately suppressed material facts to mislead this Honorable Court. All the allegations and averments in the said paragraphs are denied and the petitioner is put to strict proof of the same. Since the petitioner has made the allegation in the present application, I have sought to ascertain the real facts of the case. I have been informed by defendant number 12 that the facts as stated by petitioner are incorrect and that there has been deliberate and willful suppression of material facts with regard to the knowledge and role of the petitioner himself in the transaction. The petitioner himself was fully aware and involved with the sale of the assets of defendant number 35 company, and he himself was a beneficiary of the sale proceeds, whereby the Union Bank of India loan against account number such and such was adjusted. Millard, a letter I have annexed. It is evident from the said letter that the said Union Bank of India loan was a loan for rupees of 2.34 crores sanctioned by Union Bank of India to the defendant number 5, 7, 9 and 12 for the purpose of liquidation for the defendant number 41 company upon equitable mortgage of the asset of the defendant number 35 company. It has always been a claim of the petitioner defendant number 5 that the defendant number 41 company is his company which is under his control and management. At the relevant time of sanction of loan, the petitioner himself was one of the 2 directors of defendant number 35 company. The narration with regard to the sale of property of the defendant number 35 company and the alleged grievance of the petitioner said to be arising therefore are nothing but a farce and pretends to mislead this honorable court and to confuse the proceedings. I say that the amendments made in the made in the said paragraphs under reply are barred by the provisions of the Companies Act 2013 and are not maintainable before this honorable court. Moreover, the said averments and or allegations which are subject matter of the earlier application IAGA 14 of 2021, in which no interim order was passed on a contested hearing and subsequently having failed to produce any order in the said application, has been recently withdrawn on November 17, 2022. However, withdrawal of the said application will not make any difference as the said property is praying for the similar reliefs in the present application. I say that in the foregoing paragraphs under reply, the petitioner himself has used the words mismanagement and operation and also the word oppressive in nature, and as such, in view of such specific averment made in the said applicant himself, the instant application is not maintainable in view of the specific bar as provided under the provisions of the Companies Act 2013. So, Millet, all the points are taken by me. Now, Millet, may I show Companies Act, Millet? Companies Act.
No, Companies Act, you see, that is a question of law. You deal with that in your written notes of arguments.
So I'll just show Millet one section, Millet section.
That is there. So what is barred under law?
Yes.
You deal with that in your written notes. Now you just point out the relevant factual aspects.
Millet, I am also carrying GA40 brief of GA14, their application. GA14 টা আছে এখানে GA14. Millet, Millet, till they take out, may I give my copy, Millet? I'll give a copy to your lordship, Millet, GA14. এটা খুঁজে রাখবেন, ওটা আছে GA14, এনাদেরই ফাইল। ডিসপোজ অফ হয়ে গেছে, কিন্তু জাস্টিস কৃষ্ণা রাওয়ের একটা অর্ডার ছিল ট্যাগ অ্যালাং করে রাখা। অর্ডারটা আছে, দেখি না। Millet, I have made a comparative একটা কপি দেন না chart. Millet, where Millet identical allegations were raised. Millet, may I hand over? I'll give a copy to my learned friends also. Millet, kindly keep GA number 14 and 16 side by side. Millet, the material allegations are all identical. Millet, like for example, kindly takes page 24, paragraph 21 on GA14.
Page 24.
Paragraph 21.
Yes.
Now, Millet, GA14, Millet, paragraph 21, will find Millet page 33, para 34 of Millet GA16.
Para 33.
Yes, page 33, para 34.
Page 33, not
para 34 of GA16. Both are same. But for that, Millet, the comparative chart, Millet, I have prepared for your lordship.
Yes, page 33, para 34.
Yes.
Yes, para 34.
Same with Millet, page 24, para 21 of GA40. The main allegations. Now, Millet, next kindly see of GA14, page 27, paragraph 34. GA14. Which my lord will find At page 58, para 78 of GA 16.
Page 27.
27, para 34.
Yes.
That my lord will find at page 58, para 78 of GA 16.
Anyway, so comparative study.
Competition for that, I am not repeating.
Yes, comparative study.
My lord will go through it. My lord will find the similar verbatim reproduction of the allegations. Now, this application was kept pending, GA 14. GA 14, they failed to obtain any relief. They moved before Justice Saraf.
Anyway, it was dismissed for default.
No. They have been refused with any interim order, number one. Now, it was up for filing of affidavits, GA 14. During the pendency, we filed our opposition to GA 14.
But they
Did not file the reply. They come up with GA 16. In 15, in the meantime.
No, GA 14 was filed when?
In 2021.
2021. And
this is 2022.
2022.
Yes. With similar reliefs, similar averments, similar allegations. Now, kindly see the affirmation date. That will become clearer to your lordship. GA 16 affirmation date.
No,
18th May 2022, page 76.
Yes, 18th May 2022. GA 16.
GA 16.
So in GA 16, was it disclosed that GA 14 is pending?
GA 14 was pending. We all indicated before your lordship's court.
No. In GA 16, this point was taken that.
Millard, I don't think so. It has been indicated in GA 16 that GA 14 is pending. There is no pleading. We came up in opposition, took this point. Now, Millard, on 17 November 2022, they withdrew GA 14 without obtaining any leave. To file afresh or self cause of
it is there in your affidavit in opposition. This order.
This order? No. By that time we have exchanged affidavit in GA 16.
Yes.
Now, kindly takes comes back to my opposition once. Kindly comes to page 43. 43.
Yes.
This was the order of GA 14, which I am talking about. The injunction application has been filed after 8 years of the suit. The allegation being made in this application is that one of the companies that is allegedly part of the joint property is apprehended to be sold. Apart from the statement in the plaint that is the property is part of joint property, no other proof or evidence has been provided in the present application. Accordingly, let evidence be exchanged. No appeal filed.
Anyway, so the prayer made in GA 14 is the same.
Same
prayer.
There has to be some additions because addition of 21 till 2022.
Okay.
Now, Millard, kindly turns the page.
44.
Page 40. No. Don't know. Now, Millard, kindly page 51 of my opposition.
Yes.
Now, Millard, he has said that 6A Ironside Road property was sold. Millard, kindly see the mortgage letter issued Union Bank of India. Addressed to whom? The first one.
Yes.
The applicant. He says that I am unaware of. Kindly see serial number 1. 6A Ironside, Windsor Palace, 6A Ironside, third line, my lord. Serial number 1.
So this is dated 2014.
14.
Okay. And application is made 2021.
22, 21, 14, GA 14, 22. We have showed these letters, Milady, before Justice Saraf, when Milady it was moved prior to exchange of affidavits. Now, Milady, directions were passed for filing affidavits. We filed our objection. No reply filed. GA 16 comes into the picture. In the meantime, GA filed GA 15. They withdrew it.
And then
GA 14.
GA 14 was pending. They also filed GA 15 because this is GA 16. They withdrew GA 15. They again filed GA 16.
If applicant, you can have 5 courts.
And Milad, the same applicant, time and again. It's like seasonal, Milad. 21, 22. Whenever something he doesn't get a Milad, the value he is thinking of, Milad, he files an application and comes up before this honorable court.
So that may be taken into consideration that what was the prayer in GA 14 and thereafter
Yes.
GA 16.
Kindly see, Milad, the prayers. Milad, may I come back on because I have 3 p.m. fixed paper before just Urjit Banerjee's bench, a special bench is being constituted.
Okay.
I'll continue on 23rd.
Yes, record an order. Learned advocates for the parties are present. Learned advocate appearing for defendant number 1, 2, 3, 4 and 47.
Yes, Milad. 1 to 4, 43, 47, 48, 52 and 56.
47,
43,
43,
47, 48,
47, 48,
52, 56.
52 and
56.
56 submits but could not conclude the submissions. Let this matter appear on 23/9/2025 for further consideration of the submission of the learned counsel.
Any time can be fixed because if I start in the morning, the entire court will get blocked. My lord will
just keeping it because it is difficult.
Very well, very
fix time.
May I take back the GA 14 Milad? I'll give a fresh copy.
Just a minute.
May I take my lord?
Hey, it had. Hey, it had. এই ইয়ে এসছে এয়ার এসছে আসুক তাহলে এয়ার
Any appellate side mentioning?
Lordship, I'm with your Lordship's permission, I'm mentioning item number 120 of your Lordship's list.
120
120, appellate side, your Lordship.
128
Lordship, 120.
120 yes.
Lordship. Lordship, I'm mentioning for some precedents, your Lordship. Lordship, in this case, your Lordship, the petitioner intends to only hold a hospital in the land, which is in his record. The name and everything that is in the records, we have orders to that respect. There's a restraining order for not committing nuisance against the opposite party number 2. Just in the month of December 24, Now, after 2 months, in the month of February 2025, this opposite party number 2 had initiated a 107 proceedings, 107 CRPC and Lordship 108 CRPC. 108 CRPC relates to seditious matters, Your Lordship, which is absolutely a baseless and a frivolous case, Your Lordship, where they are committing nuisance against me. We have restraining orders against the opposite party, and then surreptitiously they come and they register the case. Lordship, I'm just praying for some precedents, Lordship.
So
can
what
we
is
take-
this application for? CRAN 1 of 2018?
Lordship, I'm
Oh, this is a 2017 matter. 120.
Lordship, item number 1.
Just a minute.
Case number.
Okay, just a minute.
Lordship, CRR 3156 Ashok Kumar Bharti versus State of West Bengal.
Yes, 120.
120, Your Lordship.
Okay. That is Ashok Bharati.
Indeed, Your Lordship.
Yes? Ashok Bharati.
Indeed, Your Lordship. Ashok Kumar Bharti versus State of West Bengal. We have come against the order challenging the proceedings 107, 108 CRPC and 116. Lordship, 108 CRPC proceedings is a seditious.
When is the next date fixed before the trial court?
Lordship, this week, Your Lordship.
Yes, record an order. Let this matter appear.
To kindly give some precedence, Your Lordship.
Let this matter appear on 11/9/2025 within first 10 matters.
Lordship, is a motion matter, Lordship.
Yes. 1/20.
Lordship, may kindly fixes a time.
No, no, it will be taken up after 3 p.m. All appellate side matters.
Much obliged.
Number 1.
I am to reply.
So today was fixed for filing the written notes from your side.
My lord, for the petitioners to reply and my lord written notes of both the parties.
For me to reply to his submission and to file the notes. I won't take much time. Right? This is a case where I have a suit for partition. Just to refresh my own memory, because it's been a while that we've addressed your lordship on this issue.
Yes.
This suit was filed by me
Yes.
initially against the defendant in respect of my lease that was granted pursuant to an order passed by the court. I filed the suit. There is a decree in my favor for specific performance. The lease is to be executed in my favor. In execution, the lease is executed in my favor. Then there is a disturbance apropos my possession. I filed the suit in 2005. Your lordship recalls, by initially there's an ex parte order of injunction. Then that injunction is confirmed. During pendency of the injunction, there is encroachment out of 16 bighas of land on 2 bighas of land. Now I file I have to amend my suit and I make it also for recovery of possession. Because the suit becomes for recovery of possession, the valuation increases. Order 7 Rule 10 application is taken out. The suit is transferred. Return. Plaintiff is returned. It's gone before another court. We had the order of injunction that was there on the suit now being presented before the court, which has the requisite jurisdiction on that day post the recovery prayer coming in. My injunction is refused. Is carried in appeal. That order is sustained on the ground that there is no basis for which an injunction ought to be granted. We had addressed your lordship on the issues primarily on 4 counts. 1, that there is a decree, there is a lease that is executed by a process of court in my favor in respect of the suit property. That decree and that lease that is executed through a process of court is valid as of today. I have a right that emanates from an order and an instrument that's executed post that order and the decree. That right today that's emanating from a process of court cannot be nullified. Second, even if there is a dispute apropos possession, court is not to undertake a mini trial at this case if I can prima facie show that there is a semblance of right, and I use this word very consciously because that is the word that your lordships have
You
used.
have been able to show before the trial court regarding your rights.
Yes, that right
What-
is a
what
matter of
was-
record.
What was the prima facie facts you have been able to show before the trial?
That's right.
That
My
is
lord,
the thing.
my first argument which I had made before your lordship is probably there's a jurisdictional error in, and I'll rely on one judgment that my learned friend has cited. There is a distinction between a prima facie case and a prima facie title. Prima facie case is not whether I will succeed in the suit or not. Prima facie case is enough where I have a chance to stand trial or not. If I can show that, then relying on the Farid Court judgment and 2018 judgment, we've shown that where I have shown a prima facie case which is distinct from showing prima facie title, the court should maintain or rather preserve the subject matter of the property. Unless the defendant comes forward and pleads that if the subject matter is not maintained, then they will suffer irreparable loss or prejudice. The test is slightly different once I come back and satisfy the court. Now, with regard to my prima facie case, my lord, it is an undisputed position today that there is a decree that was passed based on which the lease was executed. This instrument was executed pursuant to an order passed by a court of law. Today, if this instrument is not set aside, my right under that instrument cannot be assailed. And this is my suit. But otherwise, the court will have to return a finding that although what is happening is the defendant today is basically setting up this court, my suit court, against an order that has already been passed in another court. One court says you are a lessee. You are entitled to a specific performance. I'm executing the lease deed in your favor. And that lease deed in another suit, the defendant is saying very well, even if you have a lease deed from an order of court, I'm going to do what I want with the subject property. That order is not assailed anywhere. So if I may put this question to myself, then what happens to that decree?
Anyway, the question is whether prima facie you have been able to show that you have a good case to get an order of injunction. That is the thing.
That
This is
test
an
is,
interim order.
that's right. So the test that your lordships have always applied is I have to show a prima facie case to go to trial. If I can show a prima
Then
facie
balance
case,
of convenience and
then balance of convenience is irreparable loss. That balance of convenience is irreparable loss also a test that I'll just show that. But the other aspect that they've come up with is to say that I am not in possession. But with extreme humility and with a lot of respect to my brother here, the fact that whether I'm in possession or not is something that the respondents today want this court to undertake in the nature of a mini trial. We have shown judgments to your lordship. I will beseech your lordship to I'll take your lordship back to the judgment once more. That there was one judgment that we had cited where on the basis of a recovery certificate, a sales certificate was issued. That sales certificate showed that prima facie I had a right to possession. Well, lease, once it's, let us today say that your lordship in a suit for specific performance grants lease in my favor. That lease is naturally presupposing my right to be in possession.
Yes.
If that right today to be in possession cannot be the subject matter in my suit, because your lordship decree is there in my favor. If the decree gives me a right to have a lease, then I also have a right of possession. That right of possession or not is something that will have to be tried. Well, if today the defendant's or the respondent's contention is to be allowed or accepted, then the court will actually have to do away with all the settled principles. In other words, to say prima facie will mean prima facie title. At the ad interim or the injunction stage, court will undertake a mini trial. Court will have to return a finding today that if I am to not succeed and where there's a jurisdictional error by both the courts, they've completely overlooked the fact that there is a decree in my favor granting the lease to me. That court decree and that lease that is executed pursuant to a process of court can't be put into the bin. Another party is now coming up and setting a rival claim saying that you have a lease, but I will go ahead and construct and do what I want in the property. So my first submission is that prima facie right to seek an injunction emanates from an order of court that is passed. Because that deed of lease is, and I can't lose sight of the fact while I'm addressing Your Lordship that this is my suit. Why I'm repeating that is because the lease is not under challenge here. So it is going to put the entire system in such a situation where, despite an order of court, another court of concurrent jurisdiction will hold that you have a process, you have a decree of lease, you have a lease, but your possession I will not secure. I will allow the property to be wasted and to come to such a situation that even if I succeed, it will be impossible to revert. That is the test Your Lordships have always applied. If the situation is such that can I be restituted, if the construction is made and they come in and with a lot of gall, they come and tell the court, we are making a construction. There's a stop work notice on record. Against this defendant or opposite party, there's a stop work notice. If they're allowed to make a construction, my lord, while the suit is pending, considers this, that if I succeed, then what has happened? And this test Your Lordships have applied, not once if Your Lordship looks at one decision that we had cited, and this is not something I'm citing again, Lord, I understand that it's unfortunately been a while since we've been able to address Your Lordship on all this. 410. And I'll come to the aspect of possession. A lot has been argued on the aspect of possession.
No, you have argued that. Now you have to just take the points of law and clarify.
Correct. I'll just do that. So on facts, I won't trouble Your Lordship any further. Just judgments that they have cited, I'll deal with. But Your Lordship will just have a look at one. Sorry, please have a look at this once, my lord. There's not something that I'm citing for the first time. Please have a look at paragraph 10. 48, SCC 488. Paragraph 10. Be that as it may, Mr. Sachar is right in contending that unless and until a case of irreparable loss or damage is made out by a party to the suit, the court should not permit the nature of the property being changed, which also includes alienation or transfer of the property, which may lead to loss or damage being caused to the party who may ultimately succeed and may further lead to multiplicity of proceedings. In the instant case, no such case of irreparable loss is made out except contending that the legal proceedings are likely to take a long time. Therefore, the respondent should be permitted to put the scheduled property to better use. We do not think in the facts and circumstances of this case, the lower appellate court and the high court were justified in permitting the respondent to change the nature of the property by putting up construction, as also by permitting the alienation of the property, whatever may be the conditions on which the same is done. In the event of the appellant's claim being found baseless ultimately, it is always open to the respondent to claim damages or in appropriate case, the court may itself award damages for the loss suffered, if any, in this regard. Since the facts of this case do not make out any extraordinary ground for permitting the respondent to put up construction and alienate the same, we think both the courts below, namely so and so, erred in making the impugned orders. In the records before Your Lordship, the opposite party or the respondent, the defendant in my suit has made out no such case of irreparable loss that they will suffer in the event the subject property is not preserved. Well, this is the test that Your Lordships have applied. This has been again reaffirmed in 2018. We had cited this following Farid Code. two more aspects, my lord. May I just beseech your lordship before I conclude? Two aspects, your lordship will just make a note of, and I'll deal with the judgment straight away. For once, my lord, please have a look at my reply that I had filed. (28) of my affidavit in reply.
Para 28.
Page 28, my lord, of my
Page
affidavit. Page
28.
28 of my affidavit in reply.
That is the annexure.
Yes, my lord.
Yes.
Your lordship will find an advertisement of 11th of March 1997. Left-hand column, second advertisement, beginning with the name heading notice. In the court of the 10th Assistant District Judge, so and so, title execution number, so and so. The cause title is there. The name of the petitioner, your lordship will find. Take notice that the decree holder has filed the execution case for the execution and registration of the deed of lease for a period of 99 years as per agreement dated so and so in respect of the suit property given below through court. The judgment debtor may appear and file objection, if any, on or before 19 March 1997 to learned court. Otherwise, the execution case will proceed ex parte. Suit property is identified. Same thing, your lordship will find in page 32.
Yes.
This is 28th of March, page 32. At the bottom, my lord will find the date. It's in Telegraph. 28th March 2003, right-hand column, to whom it may concern. The farthest column. So and so, pursuant to the order passed by Learned Civil Judge, Senior Division, High Court, Alipur, my client is the petitioner, is the lessee in respect of a portion of the above land. Any agreement for sale, lease, or tenancy by anyone with the lessor therein shall be in violation of the deed of lease dated so and so. For such act, my client shall not be held responsible in any manner whatsoever. Nothing with regard to these two. Now, one most startling fact, and I'll come straight away to the judgments. Well, a lot has been argued and a lot of judicial time has been taken. Well, I'm consciously not using the word wasted.
Anyway, regarding facts you have submitted only
Yes.
with regard to the judgment.
Yes, just on the law once.
Yes.
Your lordship will once have a look at my revisional application. This is just on the law. Because an argument has been advanced that I have nothing to show that I have been in possession. This line your lordship would have heard time and over again with a lot of emphasis. But I am slightly unsure as to how such a case could be even run in court. Your lordship will just have a look at two documents. And this is an order of court, so I'm not relying on any documents here. Page 56, your lordship will just have a look at. This is an order of 11th of, I'm sorry, page 56.
Yes.
This is in my suit against this particular defendant.
Yes.
Order dated 11th March 2008.
Yes.
Defendant files Hajira, petition 151. Case record is taken up for hearing 3912. Please mark the next four sentences, three sentences. At the time of hearing, learned advocate for defendant, same defendant, contended that the defendant has no objection with the order of ad interim injunction passed on 5th September 2005 is made absolute. And what is that order, 5th of September 2005?
Hereafter, learned advocate for the plaintiff. That is
also contended that he has no objection with the ad interim order is passed is on 5/9/2005. This your lordship will find, this order your lordship will find at page 45.
Yes.
Please give it a cursory glance, my lord. My case was that I am in possession. My possession is being interfered with. And at the bottom at page 46, your lordship will see, hence, both parties are directed to maintain status quo in respect of nature, character, and possession of the suit property. And this is passed on my plaint with the assertion that I am in possession. Now, my lord, as we stand before your lordship today, I'm not on 710. What is the effect of it? I'm not daft to argue something that's not available to me in law. I'm on a different point here. On the allegation that I'm in possession and you're interfering with my possession, court records it and passes an order of status quo. You go and consent to that and have that order extended. Today, can that party come and argue that I'm not in possession? What is going to be left of this? The same party is being allowed to take contradictory stands in different proceedings. And in the High Court, he comes and says, I have nothing to show, I'm in possession. Lower Court, he goes and consents to it.
So that is on the matter of record anyway.
Yes, that matter of record, matter of an order passed by a court of law, and matter of conduct. Conduct, because my learned friend has also cited the same judgment that a party cannot take contradictory stands in different proceedings. And that is exactly what your lordship is being asked to countenance here. I could have understood if he had filed something and then said, my allegation was I'm in possession, you're interfering. That gets considered in page 56, 57.
Anyway, that is there.
Yes, no, that is
Which
there.
decision you want to rely now?
Yes, my lord, one. Decisions we had already placed. My lord, we've already cited decisions. Your lordship would have made a note of it. But I
dealt with the decisions also cited by your learned friend?
No, not in the note. No,
you have to deal with those.
Yes, in the note I will, but if I may just indicate the basic points on which he cited decisions.
Yes, there is a compilation.
Your lordship has a compilation.
I think you have filed a compilation.
You filed a compilation. The top sheet.
Yes.
This compilation, if your lordship looks at it, look, serial numbers 1, 2, and 3 are on suppression of fact. Well, it is absolutely clear there is no quarrel with the proposition.
Okay, by the plaintiff and who have obtained injunction.
No one has obtained injunction here.
No, 1, 2, and 3 deals with the suppression of fact by the party who has obtained injunction.
Correct. So the point that they seek to urge is I have suppressed facts, and because it's an equitable relief, if I have suppressed facts, I'm disentitled to.
Whether it is the case of the defendant or not, that has to be seen.
No, that's one. Second is not every suppression is material. It has to be a material suppression for your lordship to hold. Because of that, I'm disentitled to an injunction. There is no quarrel with the proposition here.
Yes.
There can't be a suppression.
That order 39 rule 4 permits the court to vacate the order of injunction.
If there is an order of
and not to extend it.
That's right. If there is an order of injunction. Here there is no order of injunction. I'm seeking an injunction from your lordship based on what I'm showing here. And the suppression is not a material suppression. Every fact is not a material fact. But facts that I need to prove to get the relief in my suit. That is a material fact. What his defense can be, that is not a material fact for me. That's for him to come and show. The other, with regard to serial number 4, 5, and 6 are all on Order 7, Rule 10. That is the proposition of law. I am not disputing it. But they could not understand what I was addressing your lordship on. It is not on what is the effect of Order 7, Rule 10. I am on the conduct of the party.
No, Order 7, Rule 10, that is the power to transfer.
That's right.
That is there.
No, Order 7, Rule 10, power to transfer. But once I'm taking it out and going before the court which has the jurisdiction to receive, then a de novo consideration starts. There is no quarrel with that proposition. What I wanted to address before your lordship and what we've urged is that in 2005, when you consent to that order of me being in possession and therefore status quo, later you can't come on and say I'm not in possession. This dichotomy in stands is not permissible in a court of law. So his serial number 4, 5 and 6 is what is the purport of Order 7 Rule 10. That is what it is. I take it out and go to another court that can receive it. If it goes to another court, it starts afresh. So I think they wanted to urge that because I have to start afresh, my injunction will not continue. True. But how do you tell one court that I'm consenting to you extending the injunction because I agree he's in possession? And later in 3 years' time, you go and say that no, he's not in possession, which is mean you're dispossessing me. And please examine, my lord, to what extent your lordship today in a 227 court will have to embark on this investigation of proper possession. Disregards all my documents. I'm simpliciter going by orders of court. Your lordship will have to now undertake a mini trial to hold that, look, really, he is not in possession.
To be dealt with 4, 5 and 6. And
Order 7 Rule 10.
Yes.
My lord, paragraph serial number 7, I'll rely on, my lord. Your lordship, it starts at page 53.
53?
The judgment serial number 7 of the compilation.
Yes.
2006 Kishore Kumar Khaitan. 2006 3 SCC 312. Well, every judgment has to be understood in the facts of the case.
Yes.
Here your lordship will find in paragraph 11 and 12 that this was a case where an ad interim mandatory injunction was being passed to put some party back into possession. There the test was laid down. Well, from Dorabji, Kowasji, all those judgments, it's on a different footing. When I'm asking for a mandatory injunction, I'm compelling performance. For compelling performance, there are certain attributes which have to be looked into. I am not asking your lordship to put me back into possession of those 2 bighas that they've taken away. I'm saying that the suit property.
The present status be maintained.
That's right. And
you are not in the present status with regard to nature and.
That's right, Manoj. I'm grateful. That has to be done. Well, your lordship has far more experience than I can even imagine. Otherwise, what is going to happen to the suit? So this, in fact, paragraph 13, I want to rely on just to identify the contours of the jurisdiction of Article 227. The paragraph 13 of that judgment, if your lordship sees, the jurisdiction under Article 227 of the Constitution may be restrictive in the sense that it is to be invoked only to correct errors of jurisdiction. Please mark the next sentence, my lord. I request your lordship. But when a court asks itself a wrong question or approaches the question in an improper manner, even if it comes to a finding of fact, the said finding of fact cannot be said to be one rendered with jurisdiction, and it will still be amenable to correction at the hands of the High Court under Article 227. And I want to heavily rely on this. So this argument of finding of fact, nothing turns on it. If you've recorded a finding of fact posing a wrong question unto yourself, and the question had to be twofold. One is what happens to a decree that you got through another court? And second, what happens when you've agreed to me being in possession in 2005? Then what happens? So this concurrent finding of fact, it doesn't help them. This question of fact itself is asked or answered incorrectly. And I want to rely on paragraph 13. And just to highlight, just a sentence immediately after that, your lordship will see here, the jurisdiction to grant an interim mandatory injunction could be exercised on a finding that on the day the order of maintaining the status quo was passed, the plaintiff was in possession. Completely different from what I'm asking here. In fact, I'm asking, please ask them to maintain status quo. Mandatory injunction, this is status quo ante. And serial number 8, 9 and 10 of the judgments of the compilation. My lord.
Your prayer was for not to change the nature and character and
Character
not
of-
to alienate.
That's right, my lord. Because my suit property is of 16 bighas. You throw me out of 2, remaining 14. A lease deed executed through a decree. Some other party is going to come and say, I'm going to take it away.
Yes. So
My lord,
that is
serial
there.
number 8, 9 and 10
Yes.
are also on the jurisdiction of court under Article 227. I have absolutely this same sentiment as in paragraph 13 has been echoed. My lord, your lordship's powers under 227 is not in doubt. But one must also remember that it forms the basic structure. And this is the highest court of land here.
So, but 227 is not an appeal.
Not an appeal.
That is the question.
So only thing that your lordship is looking at, if I look at paragraph 13, the judgment that they have only given, is if there's a jurisdictional error in recording these findings of fact. So to ascertain that, whatever little factual investigation your lordship has to inquire into or embark upon, only that much. And that Farid Court judgment, you know, the 2004, I'll give it in my notes, 2018 judgment is the same. Farid Court.
So that's all.
Yes, Manoj. These are my respectful summaries.
So file, both of you file your written notes of arguments
Yes, Manoj.
on the next day.
No, দিয়ে দিচ্ছি তোকে আমি। দিয়ে
Yes,
দিচ্ছি।
record an order.
Farid Court। চলো দিকে।
Learned advocates for the parties are present, are learned advocates. The hearing of arguments is concluded.
We'll give it in a week's
And
time.
parties are granted liberty to file written notes of arguments. Let the written notes of arguments be filed on, I'm giving it next Monday,
My lord.
8/9/2025. Let
Yes.
this
Today is 8.
15/9/2025.
Yes.
Let this matter appear on 15/9/2025 under the heading to be mentioned.
Only one thing, as far as the judgment is cited, in our records, we could not find that it was relied upon, but even then I will not object to it.
Anyway, whatever you cite, you deal with that in your written notes.
18 on which this relies has been dealt with.
Yes, it's the same thing. We can just deal with it in our respective notes. Make notes also.
Yes, give the written notes along with compilation and list of dates.
We shall do it. Along with list of dates, no?
Yes, list
Very
of dates and compilations.
We need to put in our compilation additionally because it's already there.
No, compilation is there. You file your list of dates, that is your written notes of arguments.
Making
And rely
reference
on
to-
these things.
Yes. That we have.
I will make it together.
Yes, this list of dates, compilation and the written notes.
Yes,
Very
we
well.
shall.
Very well.
Very great from you.
না, এটা কি?
Very good.
না, আর hearing হবে না, শুধু written notes of arguments file করে দেবে আর কিছু। হ্যাঁ, only written notes, hearing is concluded. 15 তারিখে, to be
There is no confusion in our mind. We are
Yes.
On 15th we come
yes,
back with the written notes.
Just the
and
written notes and
standard compilation, etc.
grateful.
Oblige your lordship.
Party number 2. 3, 4, 5.
My lord,
Why,
I am
I
for
am
the
for the
petition.
respondent, my lord. But we have served a notice upon him to serve a copy of the revisional application that
But
has
for
not
the
been served
petitioner.
upon. My lord.
I am the petitioner. My lord, one indulgence.
So there was the matter was heard and admitted.
My lord,
no, my
it
lord,
has been
it is not
upgraded
admitted.
by mentioning
Yes.
the moment we find that it is listed, we have given a email as well as WhatsApp to the
Therefore,
Petitioner. I am for the petitioner.
to the council for the petitioner that we should be served a copy.
My lord,
Why
one
we have
indulgence.
done this, my lord, we are saying because list of cases she has filed, she is not permitting learned trial court to proceed
My
with
lord,
the
I am the petitioner of this case. Let me.
High
what-
Court has, Honorable High Court has given thrice direction
Okay,
to
what is
complete the trial within 3 months, and line after line, she is
Wrong
filing
submission.
the
It's an expiry order.
and
so what,
taking time before the learned
so what
trial.
is the order passed? Let
My
me
lord,
see.
this
But we have
impugned
not
order.
served with a copy, my lord.
This is a case.
No, what is let me see the copy of the order.
Copy of the order. This is the impugned order, my lord, last.
Copy to the
According the direction of the.
My lord, kindly see.
My lord,
Just a minute.
16th August 2024 order passed by the Learned CGM Howrah. The order passed in respect of the 14.
This revision is in 2025. There are 5 applications. That is why I'm saying give application so that I can assist the court.
Just a minute.
Disturbing.
So next date is fixed. So case is already pending before this thing.
No. This case is disposed of. This is the 14th CRPC application, transfer application. I filed this case.
So you are challenging this transfer application?
No.
What are you
part,
challenging?
Part.
Part means
Part.
what part?
My lord, the impugned order has 2 parts.
Yes.
The honorable, the learned court.
Impugned order date.
Yes.
60.
Not giving the copy. That is
16th August 2024.
2024.
Yes.
When revision is filed.
My lord.
Because section 5 will be applicable.
Now question is.
Yes.
Yes.
My lord, the order has 2 parts.
Yes.
The learned court has already allowed my transfer application.
Yes.
Due to huge favorism was taken the OP from the learned court. My allegation was there. And another part, the first paragraph, before passing the order in respect of petition dated under section 4 to 10 Code of Criminal Procedure 1973, let me deal with the petition dated 9th August 2024, filed by the petitioner on the ground stated hearing.
Paragraph are you stating?
The first paragraph. My lord.
Yes.
Before passing, my lord, got the
yes.
The first 2 paragraph. This is a specific direction of learned CGM
yes.
to the OP, opposite party's advocate.
Yes.
My lord, kindly see what is their conduct. That's why the learned CGM passed this order. My lord, learned advocate of the respondent opposite parties are directed to follow the court practice and procedure henceforth. Accordingly, the petition dated 9th 2024 filed by the petitioner is disposed with such direction. This is, I am challenging this part.
This is another attempt to delay the entire process.
Which part you are challenging?
Your lordship will never be understand to his petition. Kindly see this. Kindly see this. The honorable court direction. Just I'm.
No. Let me consider the impugned order first.
But he will not.
Which paragraph you are aggrieved by?
He is not
my lord.
Copy.
Before passing,
matter is not admitted. The question of copy does not come.
My lord.
Let it be admitted thereafter.
I will assist because lots of suppression.
Okay, wait. After it is admitted, you are directed to appear. Then only you assist. Let this matter be admitted first.
My lord, admitting these sorts of applications.
Very well. You see, in all criminal matters, it is admitted.
Several applications.
Yes. No question now. Because no notice has been served upon you to appear.
This is what she is doing. That is why.
In all, you see, in all matters, at the time of admission, opposite party is not required to be served.
We have right to show what antecedent.
No. You serve when you are called for.
But this 52 cases he has filed.
verbally saying.
When you are.
He has not submitted any paper saying.
But I will assist your lordship, because section 5 is applicable.
Please, court is not asking your assistance at this stage. After notice is issued to you, you assist. Yes, which paragraph you are coming?
My lord, the order date 16/8/2024. Today is fixed for order. Impugned order.
Yes.
Both parties are present, file hajira. Already heard respective parties to the application under section 410 of the Code of Criminal Procedure 1973. Now, this part. Before passing the order in respect of the petition filed under section 410 Code of Criminal Procedure 1973, let me deal with the petition dated 9th August 2024 filed by the petitioner on the ground stated herein, considered the said application. This application filed by me, the petitioner. Learned advocates, this is the direction from the learned CGM. The advocate for the respondent opposite parties are directed to follow the court practice. The extreme harassment.
Very well. You proceed thereafter.
Accordingly, the petition dated 9th August 2024 filed by the petitioner is disposed with such direction. This part, they are all.
Very well, you proceed. I am not asking your interpretation.
Now, the record is taken for the passing the necessary order with regards to the application dated 410 Criminal Procedure 73. The main grievance of the petitioner canvasses the instant application mostly related to the biasness of the learned 7JM Howrah, which I am not going to discuss with the length, but the moot contention of the petitioner is praying for withdrawal and transfer the miss case 219 of 2018 along with the miss execution case 71 2022 from the learned 7 judicial magistrate Howrah to any other appropriate bench. Considering the ground, the instant petition and hearing the submission of the learned advocate of the petitioner and especially the respondents who submitted and left the decision before the court, I find logical and justified ground if both cases mentioned above are tried by a court except learned 7 judicial magistrate. There will no prejudice caused to either the parties in case the case were withdrawn and transferred. As such, on prayer, the petitioner miss case 219 of 2018 along with miss execution case 71 of 2022 pending before the learned 7 judicial magistrate Howrah is hereby withdrawn and transferred. My 410 application was allowed by the learned CGM. And the order, hence, the considered all the above decision, it is thus that the instant means petition under section 410 of Code of Criminal Procedure 1973 is allowed. The miss case 2019 of 2018 along with miss execution case 71 2022 pending before 7 judicial magistrate Howrah is withdrawn and same be restored to the court of learned JM 3rd Court Howrah for trial and disposal in accordance with law as expeditiously as possible. Learned 7 JM Howrah requested to transfer the case record miss case 2019-21 along with the miss execution case 71-22 referred above. Accordingly, the mark necessary notes in register. Both parties appear before the court of learned JM 3rd Court Howrah on 2/9/24 PC and let the copy of the order said by the 3rd Court Howrah and the learned 7 JM Court Howrah as well for their information and compliance. Thus the case is disposed of. This is the impugned order.
Yes.
And I don't have any objection regarding the transfer proceeding.
Yes.
My whole contention is before passing, I have filed an application.
Yes.
On 9th August 2024.
Yes.
This application is related to the extreme harassment by the opposite party and their counsel.
Matter is transferred.
Yes.
Our prayer is allowed.
Now what is
there?
What is the error in this order?
Yes,
No.
my lord. That is
Yes.
interfering.
Yes.
Kindly see.
Please.
My lord, give me opportunity. I will.
See, you are not called for to make your submissions.
My lord, we are harassed for 9 years.
No. The court has not asked you to give your views. Let me hear your learned friend, thereafter I shall say.
My lord, the learned CGM directed the opposite party's advocates to maintain.
Opposite party means the husband's advocate.
Yes.
Yes. To? Yes.
Maintain court practice and procedure.
Yes.
Now, after transferred this course
Yes.
to the learned 3rd JM,
Yes.
they again started harassment. This is the case. My lord.
No. What is your present prayer now?
My lord, my prayer, I have filed on 9th August 2008 application. That application, the prayer was show cause to the particular advocate who was harassing us.
Got an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. Upon hearing the learned advocate, this court is of the view that the matter should be decided upon hearing both the parties. As what is your name?
Pawan.
Mr. Pawan Gupta is present in court and submits that he is ready and willing to appear for the opposite party number one.
It has not served me, but I can't say.
No, opposite party number three probably. There are three opposite parties.
Three opposite party. Three opposite parties.
All the three opposite
But I
parties.
will be appearing for petitioner number, respondent number 1.
Opposite party number 1. The service upon opposite party number 1 be dispensed with.
One thing.
Uh,
I have raised the point of.
Yes. Let this matter appear 1 week after vacation and service be effected upon the respondent opposite party number 2 and 3.
2 and 3.
But just only one thing, Madam.
Yes.
The question of mentality remains.
Yes, all points of law are kept open.
My lord, may I serve the copy?
Yes, serve your learned friend here and now regarding respondent number 1, regarding others you serve it.
Okay.
Deep law.
I'm deeply.
মেনশনের সময় না
Hello.
আরে মেনশন
দাদা।
আইটেম নাম্বার 120
Yes, next.
Item number 6 7 8 9 10 11
11, Lord, I am for the petition. The petitioners before lordship are the parents-in-law who have been implicated by the defector complaint in 498 and 406, along with the husband. I have challenged by the impugned order by which, Lord, at the time of seizure, my allegation is that some of my gold ornaments have been seized by the police, which are not.
Petitioner is the mother-in-law.
Mother-in-law and father.
No, petitioner is
Mother-in-law, father-in-law,
Where
parents.
there is only one petitioner. This is which item? 301.
Oh, yes, sorry, I'm sorry. Mother-in-law.
Yes.
I'm sorry. I'm very sorry. I got it. So mother-in-law approaching before lordship, challenging an order whereby the learned magistrate turned down my prayer for return of my own gold ornaments, which have been seized by the IO at the time of the seizure.
Which page?
I'm just coming. Kindly bear with me for a minute. And on the other hand, their application for further seizure by visiting another place which is owned by my husband. The impugned order, I am challenging in the FIR. Kindly permit me first to praise the FIR. The allegation is not that that particular another flat which they are trying to seize or inspection once again, that is not the shared household. Lordship, kindly permit me to praise the FIR first. Page 13, the FIR starts. FIR is a long FIR, just one or two small portions, my lord. Kindly come to the subject, page 13, where I am reciting. Not the mother-in-law, the first name, the husband, then the husband is also a member of the bar. That's why anyway, I'm just on merits, and the parents-in-law, father-in-law, mother-in-law, all are residing. This is important. All are residing at 17 Priest such and such lane, Taliganj, Kolkata, such and such.
Yes.
This is the address. And the sister-in-law, she is also been implicated. And the FIR, your lordship will find that she is residing elsewhere, married sister-in-law. 11 years back, she was married. Now in the FIR, your lordship will search in vain. No allegation that the another flat which is owned by the father and mother reside separately and occasionally comes in this house so that not to disturb the married couple. Now the allegation, your lordship, is search in vain. No allegation in the FIR that any household, any Stridhon articles are kept there or she was residing there. Now after the seizure was made, charge sheet was filed. They filed an application for further seizure of another place to disturb me. But I have filed one application. But your lordship, this is the FIR, and their application kindly comes to their application for recovery of further Stridhon articles and another address, which is page 27. Thereafter, I'm coming to the impugned order. Page 27. But I'll be very brief. First, I have shown the address where she is stating in a FIR, that's Prince another road at Tadiganj. Here, she is seeking for further seizure of arranging the most some Stridhon articles lying at another flat, that is 12 Rosha Road. It is owned by my husband. We are residing separately there. We are not disturbing the married couple. Although it is also our house, the first one.
No, this order was passed without hearing you.
Oh, no. I have filed when this application was filed after seizure was made.
After seizure was made, you filed an application
that
return of some of the articles.
Some of the articles I have shown the invoices that these are my ornaments.
And that was
rejected. That was refused.
And the
application
by the de facto company.
Absolutely. That was not decided to be left open to the trial court to be decided on trial adjudication. My doors are closed. And
regarding the further seizure that was left before the trial.
Before the trial court, but they only the stage is that after charge sheet has been filed. Stridhon articles have been recovered. It is mentioned. All gold ornaments.
Prior to the charge sheet.
Prior to the charge sheet.
And subsequent
charge sheet filed. Thereafter they filed this petition.
So after this petition, so this prayer was allowed.
This prayer was allowed. And in the meantime, when before the next date is fixed, they file a put-up petition and trial court allowed the put-up petition and fix the date for deciding that application. Although in the impugned order, your lordship will find that the learned CJM directed the trial court to be decided by trial adjudication. So trial adjudication by evidence.
Which page is the rejection? Your rejection?
My lord. My lord, the impugned order also separate it's there, but that kindly comes to page 38 first. My trial court is learned CGM proceeded as if I have gifted this a gift. Whether it is a gift or not, that definition is not discussed. Although my case is that I have temporarily used my daughter-in-law to use temporary. Page 38 it starts. Kindly comes to the page 40 first. That rejection. Accordingly, on careful perusal of the Jimmanam and seizure list 9 March 2025, it appears that same has been seized after following the guidelines laws mentioned in the regard as such. At this juncture, the prayer of both the parties for recovery. Here mentioned prayer of both the parties for recovery of further Stridhon articles appears to be baseless. Now, again that, however, I am of the considered view that there might be some Stridhon articles remained at the new address given by the reflector company. So one by one, after charge sheet, gives a new address and wants to disturb me. And not only that, but thereafter, this is not rejected. And then finally, my application was rejected. Kindly comes to the discussions at page 42. Hence, it can be construed. The seized articles are the Stridhon articles of the defect complaint is in terms of the above proposition of law. The accused has no right thereof. As such, the petition filed by the accused person dated such and such is hereby considered and stands rejected as contest. It appears that investigating officer has submitted the charge sheet in this case. Case record is ready and mature for such and such, so it will be expedient and for also from the ends of justice if the petition filed by the defective complainant be finally disposed of by the trial. Accordingly, the petition mentioned above is kept open for trial adjudication by the transferee court in accordance with law. So my case, my claim is shut down, is not to be remitted for by trial adjudication. But this successive application, although the earlier part is baseless, but here again remitted. And now the defective complainant moved the put-up petition to decide that application prior to that.
Yes, record an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. Peruse the petition file and the materials on record. Learned advocate for the petitioner draws attention to the order dated 25/3/2025, passed by the learned Chief Judicial Magistrate at Howrah in GR number 6288 of 2024, whereby the learned magistrate, pursuant to the seizure made by the police authority, granted opportunity to the de facto complainant to agitate the issue of further seizure with regard to the Sridhon articles, but at the same time refuse the prayer of the petitioner, who is the mother-in-law of the de facto complainant, for release of the some of the articles which the petitioner claims to have been wrongfully seized by the police authority. It is further submitted by the learned advocate that the learned trial court, without applying the mind, has rejected the prayer of the petitioner. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation, pending hearing of this application. So there is no scope of any stay, because
But the
unless
stay is that trial court will not proceed with this application. I'm not praying for stay of the trial. I cannot.
No,
I cannot. Only trial court will not proceed with the application.
It may be
implementation
stay of the order dated
Yes,
25/3/2025. The order dated 25/3/2025,
that much only.
passed in GR 6288 of 2024. So far, it relates to the consideration of the prayer of the de facto complainant for further seizure.
Yes, madam.
For a period of 3 weeks after vacation.
I bow down. I bow down. Obliged.
Lordship, apologies for the indulgence, Lordship. I had mentioned a matter, Lordship, item number 120, Lordship, had fixed on 11th of September, Lordship. Lordship had inquired regarding the next date of hearing, Lordship. Lordship had inquired. I'm really I seek apology for the date. Lordship, it is fixed on the first week of November, Your Lordship.
So anyway, let us see. Let us see on 11th what can be done.
Much obliged, Lordship.
No, 12, 13,
Not today.
14,
Not today.
15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39.
My lord, I am for the petition of 39.
39.
My
yes.
lord. My lord, the petitioners are seeking quashing of a proceeding and charge sheet, where, my lord, they have been charge sheeted in a matrimonial dispute where the lady has committed suicide. These three ladies, petitioner before your lordships, are married sister-in-law, that your lordship will be finding from the cause title. Priyanka Pandey, resident of Jharkhand, and Sneha Pandey, resident of Purulia. Nikita
Charge sheet
Pandey
is submitted.
My lord, I have annexed. Your lordship may kindly come to, there were two charge sheets.
Okay, charge
First,
sheet is
your
submitted, the matter is also committed.
my lord committed. Next date is fixed for framing of charge. So my lord, we have prayed for quashing of the proceeding on the ground that 3 similarly stated accused person in the FIR
Yes.
were non-charge seated.
Now, the
And
question is, you are on bail.
my lord. So my lord, if next day charge is framed, my lord, the entire revision
When is the
application.
next date?
My lord, next date is fixed on 19th of September 2025.
Yes, record and order. Learned advocates for the petitioner is present. Heard learned advocate for the petitioner. The petitioner in the instant case have sought for quashing of the charge
Charge sheet
filed in VR case number 309 of 2021 arising out of Santaldi PS case number 35 of 2021 dated 30/5/2021 pending before learned additional sessions judge Raghunathpur, Purulia. Upon hearing the learned advocate and considering the nature of allegations, this court is of the view that necessary orders can be passed upon hearing the opposite party and upon perusing the case diary. Thus, the petitioner is directed to serve notice upon the opposite parties,
my lord,
and file affidavit of service forthwith.
my lord.
Let this matter appear 2 weeks after vacation. The case diary be produced on the said date. The petitioner, as the matter is sub judice before this court, the petitioner is granted liberty to seek adjournment before the learned trial court, which may be considered.
Deep love, lords. Deep love. My liberty to file pray for stay after CD arrives. Liberty to pray for stay after CD arrives.
No. After CD, necessary orders can be
My
passed.
lord.
Yes.
If
I have
liberty is
granted you
not
the
granted,
liberty.
and if liberty is not granted, opposite party will say that on motion
I
I
have
did.
granted you the liberty to pray for stay, pray for adjournment, which may be considered by the
My
trial.
deep love, Dada.
40, 41, 42, 43, 44, 45, 46.
46, my lord, for the petitioner, my lord, very short prayer, my lord. In complaint case, my lord, your lordship will be seen for the first time.
Let me see.
My lord, my parents, who stood as guarantor in one of the company, have been prosecuted under section 138. The children have been prosecuted. Now, kindly come to the complaint at page 16. I will just show some relevant portion, my lord. Complaint.
By whom was the check issued?
Different person. I will show. Your lordship, kindly come. Just few pages I will show. Page 16, your lordship, kindly come. The copy of complaint I have shown as accused number 5.
16.
Page 16, my lord. Your lordship is getting?
Just a minute.
Page 16, the copy of complaint. Now, my lord is getting item serial number 5.
Yes.
So, Ruchira Surika. She is petitioner before your lordship.
Yes.
She is an accused. Now, my lord, may kindly come to the complaint, paragraph number 2. Page 18. First time I am looking this type of prosecution. The accused number 5 and 6 are the legal heirs.
Para 18.
Page 18, paragraph 2.
Paragraph 2.
The accused number 5 and 6, I am concerned about 5, is my client, Ruchika Sureka, are the legal heirs to late Chandra Prakash Agarwal and Chandra Devi Agarwal, who are ones of the guarantors to the various financial extended to the accused number 1 by the complaint bank. Now, bank has also prosecuted them. And this is case under section 138.
So, this is the complaint by the bank.
Bank 138 proceeding. How it can be? Kindly come to page 4.
Proceedings. These persons have not issued the check.
No.
But they have been implicated in 138 proceedings.
Yes, because their parents were guarantor.
Because the person who issued the check, their parents were the guarantor.
No, the person who The person who issued check is accused number 1, Beneath Oils Private Limited.
Yes.
We, not even we, our parents stood as guarantor of main accused Beneath Oils.
What is the relationship between the petitioner and the accused number 1?
We were working in the company.
Petitioner and the accused number 1. This petitioner.
This petitioner is not working in the company. Our parents were working in the company.
Okay. So this petitioner's parents were working in the
Company.
complainant company.
Yes, they stood as guarantor for the
Their
main
parents.
accused. Yes, so parents will be accused. So parent has died, and the children are prosecuted for the
Yes,
first time.
record and order.
Looking this type of, and they have admitted this in complaint.
Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. Learned advocate for the petitioner submits and draws attention to the complaint petition, wherein it is contended that the present petitioner, who is an accused number 5 and 6 in the said complaint, are implicated as because their parents were the guarantors with regard to various financial facilities granted to the accused number 1. It is submitted by the learned advocate that although these petitioners are not anyway related to the incident, and if at all any case is to be instituted, it is to be instituted against their parents, but they have been implicated without any reason. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings with regard to the complaint case number 66896 of 2021. Now pending before learned 11 Judicial Magistrate, Calcutta, for a period of 4 weeks after vacation.
Deeply obliged, Lordship. Deeply obliged.
রেখে দিন আর 2-4টে বা মেনশন করে দিতে পারেন any person appearing for the petitioner.
Mentioning for the list.
তো কেউ নেই পিটিশনারের হয়ে।